Got a really important subject here today. And before I get into that, my name is Ethan Ostroff. I'm a personal injury lawyer in the Philadelphia area. My goal is to make sure your future personal injury case is protected. By following my page and hitting that subscribe button, I promise that you will understand how to protect your future personal injury case, because guess what? Nobody ever expects to be a plaintiff in a personal injury case. If you are a plaintiff in a personal injury case, you need a good lawyer. Click that link below where you can schedule a call with me or a member of my team to make sure you're protected. So, how to prepare for a mediation in a personal injury case. Mediations are a high pressure, very stressful thing that many plaintiffs go through. Now, a mediation is where both parties or all parties, sometimes there's more than two parties, come together. They sit at a table, either in person or over Zoom now that the pandemic has hit, and there's someone in the middle. They are called a mediator. That mediator, their goal is to get the case resolved between the parties involved, whereas your goal as the plaintiff is to maximize your settlement. So what a mediator tends to do is their goal is sort of to leave that day with the case resolved, of course, but with everybody sort of feeling like it's a lose-lose. Let me explain. When you go to mediation and you settle your case, you're going to get less than you want, and the insurance company is going to pay more than they want. That's sort of how a settlement can feel. It doesn't feel like a home run most of the time when you go to mediation. The reason you're going to mediation is that one party has a position that the case value is X, and the other party has a case position that the value is Y. And really the goal is to meet somewhere in the middle. So really, to mediate a case, both sides have to be a little reasonable and willing to give to find a middle ground. Sometimes plaintiffs and the personal injury lawyer protecting them and representing them, they will not budge on their demand. That's usually not a strategy to get a case resolved. Sometimes the plaintiff's lawyers need to move a little bit, just like the insurance company needs to move a little bit. There are certain exceptions to that, though. Let's say that there is a specific policy that only has a limit of a certain amount of money. If that's the case, then your position as the plaintiff's lawyer is I'm only going to accept the liability limits of whatever it is. Let's say it was $100,000 and you believe the case is actually worth $200,000, and the insurance company, they're only willing to pay you $80,000. If you do not get $100,000 at that mediation, then you are not going to accept it. So really what the insurance company is risking by not settling the case for the policy limits is if that case goes to trial and let's say they get a verdict of $1 million, they're going to have to pay all that. So it is mutually beneficial to try to come to a settlement a lot of the time if there is a possibility of one side or the other side moving a little closer to the middle. Now, how do you prepare for that? First, you should have a dedicated phone call with your lawyer going over the case again and again. You should reread your deposition transcripts if you took a deposition. A deposition, keep in mind, is just a question and answer session under oath, and there's a transcript that comes with that. You should reread your entire transcript to make sure you understand what you had testified to in the past. Your lawyer also should just make sure that I know that you went through it, but that you understand your medical records and you understand what it is exactly that you went through. Because sometimes it's a little foggy when you go through so much. How else to be prepared? Ask your questions of your lawyer before you start. They will make time for you if they are a good lawyer to make sure you feel prepared. Write down a ton of questions. Make sure that you also write down the things that have really been affected by this incident. If you have been affected by this incident in a certain way where you can't do things that you used to love doing, you should write down all the things you used to love doing and bring that to the mediation. Because when they ask you, hey, are you still playing hockey 3 times a week? Are you still, going for runs 3 times a week? If you can truly testify all those things that you used to do that you can't do anymore, that's how you get prepared for your mediation. Other than that, just make sure that your general questions are answered by your lawyer before you go in, so you don't have questions before you go in. Because if you go in and you have questions and you start asking the mediator questions, you start asking the defense attorney questions, or you start talking a little more than you should, you really damage your case. Lastly, try to let your lawyer do most of the talking. If you're really upset with something they say, try to leave the room and pull them aside. Don't explode, because guess what? That defense attorney is looking at you and they're thinking, Is this person going to present well or poorly in front of a jury? If it's poorly, they're going to want to put you in front of a jury. If it's well, they're going to probably pay you quicker. So really, you should try to be very mindful of how you behave in front of these other lawyers, because that all does affect the value of your case. Hopefully you never need to go to mediation. Hopefully you never need to reach out to a personal injury lawyer. But if you do, I'm happy to be there for you. Click that subscribe button, follow along, make sure your future personal injury case is protected. And if you ever have any questions, I'm here for you. Thanks so much.